Well, I do family law, so a lot of the processes to make anything come to a settlement is to look at everybody's needs and figure out what the actual realities are when it comes to finances and assets and what they really want, because family law is driven a lot by passion and by emotion and not just that bottom line. So it really does take some intellectual and creative thinking to get to a resolution.
When you look back, yes, it is. During the process, you don't really realize that's what you're doing. You don't consciously think, I'm going to critically analyze this and come to a decision. I think you just find out after years that you can't just come with a knee-jerk reaction. You have to think it through. You have to know the party's objectives. You have to know the legal probabilities. And then if you have to litigate it, you have to decide what evidence do I really have. And so there is a lot of analysis going on of how do I get to my objective. And you really do have to find a path that makes sense and covers everybody's needs, and you can't work impetuously or just... Sometimes your intuition just happens because as a lawyer you learn to hone your thinking and analyzing skills. But many times you have to just sit back, ask questions, talk to different people, try to come up with some sort of an agreement or a solution. Accurate, often in any kind of law case, accurate usually use experts. You'll use forensic accountants, you'll use a real estate appraiser. The accuracy of your evidence is usually put on by experts, because you can't rely on the client. Your next question, you had three parts of that. It was accurate, relevant,
and clear.
And clear. Okay. Relevant, that's also something you need to hone. That's something a lawyer really should do, because you're, when you get in these kind of cases, you're always bringing in evidence that isn't relevant. All you really want is what the judge is going to hear, because in these family law cases, there's no jury. So you're really talking to a judge who's intelligent, understands the issues. So you don't want to cloud his mind with why they did this or how it was wrong that they did this. You really want to go to, this is what we need to do to get these people with their assets divided appropriately, or to get the children psychological help they need, or whatever it is you need to narrow it. So that's a lawyer's skill. What I usually try to do is usually try to know your judges. That's part of being a good lawyer, because certain judges have been doing it forever and they know the law, so all you really have to do is give them the relevant facts, which just might be some bottom lines. You don't have to go through the whole analysis like you would for a new judge, or a judge at least that's new to this issue. So that's, if you're a good lawyer, you will try to shorten your case, because the judges have short attention spans, just like us. So that's a matter of paring down to what you think you need to prove, asking what you need to prove with the evidence you have, and then what your goals are, and streamline it. And then the last one was clear. I think that's kind of subjective. I always think I'm clear and brilliant, but I'm not sure if everybody agrees. Sometimes what I'll do is I'll bring my husband in or bring a friend in and say, if I told you this, this, and this, what would your conclusion be? And so sometimes you bounce it off other people to make sure, because I have so many facts in my head, I just think that everybody understands it. Sometimes that's not the case. So bouncing around with somebody who's completely new to the subject, sometimes that helps a lot before you actually go to court and make your argument.
I have a funny little strategy just in my own head. I tend to do things in threes. I don't know why. I don't know if it's just something I've picked up over the years or if it's just easy for me. But I almost always give three examples, or I give, in this case, and if you looked at this, and if you looked at that, three seem to work. I don't know why. That's one funny little strategy. And what was the other word you said?
Locate. Oh, locate, present.
Well, sometimes in law it's a little bit different than maybe if you were teaching somebody something or giving a discussion or a lecture. When you're in a courtroom, you often have to follow what we call precedent. You have to look at the old cases because that's what you're going to rely on. California isn't driven necessarily by statutes and laws. Of course, there's some, but in a lot of situations, they'll say, in Smith versus Jones in 1950, the court held that. And so you have to use that as your guide, that as your strategy. What you try to do is find the facts in your client's case that match the case that won. So one thing you do a lot in family law and any kind of law is you look at precedent, you look at case precedent, and you do research. And you'll put your client's facts and the issues, let's say it's spousal support, or let's say it's custody, or whatever the issues are, you'll put those issues either into the computer nowadays. My old days, that wasn't the way we did it. We had keynotes that we looked through and researched. And you'll try to find some cases that support where you want the judge to go. And when you find cases that support you, you have to look at it really carefully and see if your facts, you can argue your facts fit that case and that holding. And so that's the strategy you use. You use the strategy of that case because that's the precedent that you're hoping the judge is going to